Ready, Umberto.
Okay, so welcome again to this seminar of today, and welcome especially to the first panel, which will be dedicated to trade and investment issues under the Comprehensive Agreement on Investment. And it is my pleasure to welcome the speakers as well as all the public attending. And just a quick reminder of the, let's say, the rules of engagement. So each speaker will have 15 to 20 minutes for his speech, and at the end we will have a little Q&A session. And so without further ado, I would like to introduce Professor ZENG Wenge from Chongqing University, where he teaches international law. Hello, Professor, and thank you for joining us. And of course, the floor is yours, and for 15 to 20 minutes. I will write in the chat around 50 minutes from the beginning so that you know that the time is almost up. So please, the floor is yours, and thanks again.
I found share the. How can I share the PPT?
Yeah, I think there is a button.
On the bottom. 有那个共享屏幕，曾老师你那儿，你如果想用 PPT
在什么位置？我没找到那个共享屏幕。
下面档下面。
是一个 video audio， 还有一个叫那个什么？
然后就是共享
share 是吧？
第三个对。
好的。
It is the third from the left.
Yeah. Okay.
Okay, yeah.
Thank you.
So if you start the presentation, we can see the slide one at a time.
Yeah. Thank you. My prayer to give a presentation about the comparison and the enactments of the EU-China Comprehensive Investment Agreement with the CPTPP environmental protection provisions. For the China EU comprehension investment, have some articles about the environment protection provisions. Meanwhile, the CPTPP have same articles. This topic just compared with them and give some the enlightenment for the China. For the China, we want to the access to the CPTPP has some difficulties. So we learn from this comparison about that. This is my topic. So I just talk about the four questions. One is the key provisions and difference between the CPTPP environmental protection provisions. Second is the factor. How they affect the difference between the CI and the CPTPP environmental protection provisions. The third one is challenges to China's accession to the CPTPP. What is difficult? The last one is enactments for the China participation, negotiation of environmental provision of the CPTPP agreement. That's my topic. So. Most of the scholars know the CI and the CPP, TPP, the environment articles. So I just briefly introduce them. So CI's provisions on environmental protection provisions. In the CI negotiations, you emphasize the concept of the balance agree to the balance degree of openness and the Chinese and Europe markets, and the global multilateral pattern injection the concepts of sustainable development in the agreement. That's the first time the China and between the China and the EU have this kind of the articles about sustainable development. So. in order to achieve two overall goals, the environment protection, CI commitment to further open up the market to environment service and quantitative restriction on joint venture or investment environmental services and other aspects. For the CI's Chapter 4 regulates environmental protection provisions, forming, on the one hand, the right of states parties to take environment measures of enacting legislation, and on the other hand, imposing an obligation on state parties not to lower environmental standards in order to attract foreign investment. Meanwhile, for the main provision of CPTP environment protection provisions, this is very different from the CI. For the CI, just they talk about they have the sustainable environment is kind of the comprehensive. But for the CPTP, have some exactly articles about the environment. Article 20, Section 1, Section 2, Section 3, Section 7, and Section 8 about definition of the treaties, environmental rules, objectives, and provision on the general obligations of state party. In addition to the traditional procedures provision, the CPTP has also introduced articles on corporate social responsibility in Article 20, Section 10, and Section 11. This is different. Just very briefly introduce, they're different. The second, I introduce the factors affecting the difference between CI and CPTP environment protection. This one is just discuss the why they have the different articles, have the different structures about the environment provisions, different models. Why? So generally speaking, they have the four factors of the influence the environment law. First one, the environment law concepts. It's the idea, a different idea, make this results. CI is based on towards the comprehensive of the concept of environmental protection, and the focus on the agreement between China and EU is to promote comprehensive cooperation in economic trade and investment between China and the EU. And the way to achieve this is reach consensus on the market access of the environment service products. Meanwhile, the CPTP focus on the construction of environment systems, establishing a model of environment protection provision so as to leading countries' leadership position in the field of the environment in the region. It is precisely different. Emphasize the national interest, the different conceptual characteristics for the CPTP. The first stage just the American US have the after the Trump president we saw this CPTP. Now the Japanese and some the developed countries have the dominate this CPTP. So they have the strong role in the CPTP. So they have so many environmental articles. Factor 2. Influenced by the economic factors, the issue of environment protection as an economic tool to create values is the most convincing reason for Western countries to carry out environmental protection for a long time. For the Europe, they have a very long time legislation about the environmental law. Meanwhile, the CPPT contains a systematic environmental systems content with aim to guide the behavior and system of the contracting states in the field of the environment protection. So the system, the provisions or rights and obligations. For CPPT, meanwhile, have some of the developed countries, meanwhile, have the developing countries, they need to formalize it. In the process of EU negotiation, EU is more inclined to the actual interest of China's environment service market, hoping to the problem of domestic commitment, distribution, and modernization of legislation and institutionalization. So they have a very big progress in this area. The China have some of the market access to the EU about the environmental industry. The third one is the cultural attitude influence. It is also obviously the Chinese value of international community in the action in environment protection. Japan, the leading country of the CPTPP, and the contracting countries belong to the Asia-Pacific region. Attach importance to overall harmony is a more common thinking principle for the countries and peoples in the Asia-Pacific region. You know, the Eastern countries culture. This is traditional for this areas of the region. Meanwhile, the CPTPP emphasized environment protection, that the environmental, economic, and cultural complement and other progress, adapting state progress for the system to behavior. The third one is I want to discuss some changes to China's accession to the CPTPP. Environment provisions have some of the difficult for China. We want to the CPTPP. Meanwhile, we have some of the give some of the documents about the accession. So, but it's very very slowly to make progress. So we have some difficulty for this. The first one is the environmental legislation is inadequate. You know, in China, we have a very long time to have the legislation of the environmental law. Meanwhile, we have been ignoring the assessment of environmental impact of the various subjects in economic activities. Meanwhile, our environmental legislation still need to be improved. This is the first difficult. At present, China environmental laws formulate the many areas environmental problems are two principles, not exactly, not very detailed about that. The second is the insufficient capacity of negotiation environment terms of the risk. In the negotiation of environment terms for foreign trade, China lacks the ability to summarize the practical experience of negotiations and deal with political and environment economic risks. In the past negotiation in China, initiative in environment protection matters and failed to form an flight negotiation strategy based on practical experience. We have little about that. For example, in the RCEP, we have no environment article about this agreement. The third one change is there are differences in the implementation mechanism for the environmental protection. Just for a long time, China has mainly adopted administrative methods to deal with environmental protection issues, current environmental impact access assessment has been unable to meet the high standards of the CPTPP. So we need this new dispute resolution or mechanism about that. This is the last part. We talk very briefly about the enlightenment from China to participation in the negotiation of the environment provision of the CPTPP agreement. That to say, we want to access the CPTPP agreement. How can we learn from the CAI? The first one is establish a comprehensive concept of the environment standard clause for environment protection. This is a good one. We think is a very good one. The the environment articles is improved very quickly. So we think the CAI the sustainable development is a very good idea. For a long time, China has adopted an administrative method to deal with environmental protection issues. China's current environment impact has been unable to meet the CPTPP. So we need a new idea about that. The second is the strength construction of the environmental protection platforms and pay attention to grasp the right to cooperation regulate. We learn in China, it's very popular for the platform, for example, the internet sale platform, something like that. So it's very important words for China for the platform. So I want to use the distinctive feature of the environment program is international character. Chinese cooperation is only the environment. The principle of international law is the essential basis for ensuring access of the environment cooperation. So we have some cooperation with the EU, so I can have cooperation with another country in the environment area. So first, strengthen the construction environment protection platforms. China can make good use of existing platform and new cooperation platform for the basis. Up to now, China has signed so many agreements with the 5 member countries of the CPTPP. We have the foundation, have the basis to achieve more. Make use of the existing basis for cooperation, update the agreement with the CPTPP as a standard to make it closer and closer. The second is the grasp of the flexibility provisions and after the improvement China's environment rules. You know, for the CPT, they have very high standard for China. So meanwhile, they have some the flexibility about this environment articles. So we can use this kind of the flexible articles just as step by step. We have maybe we have some the flexible times have the some limited, so we can do that. The third is the implementation mechanism. CI's experience to stabilize in multiple missions. First of all, summarize the implementation experience for the historic point of view. The environment protection implementation mechanism developed in China can provide experience for new concepts, new system, and new model. The practical experience environment of the green development built on that, we do a little bit about that. So we can provide a money development for the implementation of CPTPP in the future. Finally, actively innovate implementation mechanism from the development, strengthen the application of the technology, information, and intelligence data to carry out the implementation of the provisions. For us, so in the RCEP, we have the digital larger country. Meanwhile, we also have some the dispute settlement articles, so we can use can make some the new dispute mechanism for the environmental law. The first, strength research on dispute provision procedures and build and comprehensive environment dispute resolution model. During the CAI CPTPP negotiation process, the parties focused on the relief of dispute and weakened study of the dispute avoidance, the smooth operation of the dispute avoidance mechanism, recur the multiple department and the cooperation of the parties. China's deep research to the dispute avoidance mechanism reduce the negative effect of the frequent environment dispute. We have this kind of the experience for a very long time. We just have some use the negotiation, use another method to the adjustment this kind of the complex other than use the dispute process. This is a new idea. Second, in the judgmental environment dispute, the understanding problem is one-sided without really understanding dispute for the environment. If the dispute resolution mechanism more coercive and efficient, it's enough to worry whether the environment factors can be properly and objectively considered in dispute resolution. Finally, in the terms of distribution settlement mechanism, interaction began to study different forms of practical and legal APP. Various specialized judicial, quasi-judicial bodies have been established. Western scholars have called this phenomenon the proliferation of the international tribunal and adjudication bodies. In recent years, the EU has proposed the EU Court of Justice, which specially established to handle various disputes in the economic and trade cooperation, has certain reference value. So we can learn from that. In the future, it may consider promoting and comprehensive environment dispute resolution model in the CPTPP. This is my presentation. It's a very brief introduce. Thank you so much.
Thank you very much indeed, Professor. And well, you were perfectly within the times we set, so thanks again. And now I will like to introduce Professor YUAN Zhenhua from Sichuan International Studies University.
In principle, on the comprehensive agreement on investment, so hereafter called CAI. The CAI aims to place and unify the bilateral investment treaties entered by China and 26 out of 27 member countries of the EU, respectively, so as to establish a unified multilateral institution framework which covers many fields. For example, inter alia, the market access commitments, information transparency, fair competition, fair neighbor treatment, sustainable development, and essential. However, it is worth noting that as for the dispute resolution mechanism, the CAI has not directly set out a set of rules for the investor statement dispute settlement, only state-to-state dispute settlements. So, and designs rather elaborated dispute settlement rules of the DS. So the investor statement dispute settlement negotiation, as we know, still remains negotiated within 2 years after signing of the CAI. So I think, yeah, it is worth considering how the state-state dispute settlement established by the ZEI provides institutional safeguards for the realization of the rights of both China and the European Union, and how to deal with the relationship between the sounds totally different dispute settlement mechanism, that is SSDS and the investor state dispute settlement. So my content will focus on the three aspects. The first, let me first introduce the framework and basic content of the CAI about its SS state dispute mechanism, and I want to introduce some features of nowadays the current SSDS dispute settlement mechanism, and here comes some possible issue which may arise out of the nowadays and the current CI, and how to deal with that. So the first objective and scope of application, that is as we know, the objective of this section is to establish an effective and efficient mechanism for avoiding and settling any disputes between the parties, and maybe only two parties, okay, within the scope of application of this section, with a view to arriving at, where possible, a mutually agreed solution. Of course, this is a quotation of Section 5, Dispute Settlement, Article 1. And this at least includes three implications. The first, the rapid prevention and resolution of disputes. Of course, that's all the parties seek for. Okay, and secondly, you're putting much focus on the effective prevention and resolution of disputes. That means, as soon as the disputes arise out of, that means, the first concern is to how to deal with that and to prevent that or avoid that, not resolve that. And certainly, that means the promotion of peaceful and amicable settlement of disputes as far as possible. That is also very important concern of both parties. Okay, and please next page. Hello.
Hi.
Okay, so can you turn to the next page? So except as otherwise provided. So according to the language, okay, when providing for the scope of application, the agreement changes the conjunction between interpretation and application from the previously used or to and. Okay, so unlike previous BIT's provisions, for example, China-Canada BIT and China-India BIT, okay. So it's a minor difference, but maybe it will cause some great change about the application scope of the agreement. So as we know, semantically, the word or indicates a choice of relationship, but does not exclude a concurrent relationship. So disputes in such clauses thus include disputes concerning the interpretation and disputes concerning application of the agreement, as well as disputes concerning both the interpretation and application of the agreement. However, if we use and instead of or, which means a concurrent or a parallel relationship, that is, a relationship with simultaneous coexistence, which means disputes shall concern both interpretation and application of the CIA. I'm not sure it does change in wording intentional or unintentional. So this is one issue about from the wording, from the provisions of this Article 2. And the second, is about the measure on the CAI. Also in the Section 5 dispute settlement mechanism, in Article 2, okay? Because, say the complaining party shall deliver the request to the other party. The request shall identify the specific measure at issue and briefly explain how that measure constitutes a breach of the covered provisions in a manner sufficient to present the legal basis for the complaint clearly. So here is another question or issues: how to define the measure. Here measure by the party. Means or treatment by the party means measures or treat by according to some articles. Article 2, Section 1 is some central, regional, local governments and authority and the non-government bodies in the exercise of powers delegated by central government or other level government authority. So here is question. I feel a little confused. Okay, maybe it is a question. So does an abstract interpretation of a provision of the CI constitute a specific measure? Does an abstract interpretation of a provision of CI, by the government, by China, by EU, it constitute a specific measure? If not, that means disputes within the meaning of Section 5, Article 2 of the CI do not include disputes arising from the abstract interpretation of the CI, but an exact measure. Okay, so apart from the objective and application scope, Section 5 provides for detailed arbitration rules, such as, for example, the establishment, composition, and panelist list functions of the arbitration panel and its terms of reference, the conditions for suspension or termination of the arbitration proceedings, the applicable law and the rules of interpretation, and as well as with making of the interim and final reports of the arbitration panel. So all of elaborated rules. And it also provides for temporary remedies, okay? In the event of non-performance of or non-compliance, the complaining party may request that an agreement or on compensation to be negotiated, or if this is not possible, that the complaining party give notice to the other party, to the party complained against, of its intention to suspend its obligations. Of course, here, I want to mention that, it is worth it is also worth noting because, this is unlike from the WTO's dispute settlement, okay? On the WTO system, if somebody is willing to make some retaliation, it must be under the authorization of the DSP of WTO, okay? So, or give notice to suspension without requesting negotiation. And of course, yes, the CI also creatively introduce the mediation procedures, okay? So it's brand new, okay? It's a brand new mechanism, at least unlike previous BITs and other free trade agreements. That is, apart from the consultation, the parties may at any time voluntarily agree to mediation with the aim to reach a mutually agreed solution regarding a measure alleged to adversely affect the investment between the parties. So this mediation procedure may only be initiated by mutual agreement and be confidential, and shall not affect the rights of either party in any future or other proceedings. And the most interesting mechanism designed by CAI, I think, is the choice of forum. Choice of forum. That means, if a dispute arises regarding a particular measure in alleged breach of an obligation under the CAI and a substantially equivalent obligation under another international agreement, here I think it mainly refers to WTO agreement, to which both parties are party. Of course, China and EU, both parties of the WTO. So the parties seeking redress shall or also will have the right to select the forum in which to settle the disputes. So once the choice has been made, other disputes settlement are automatically excluded unless the chosen dispute settlement body fails to make a decision. I think, yeah, that's very is very interesting. Okay. So as for the basic content of the CI SDS mechanism, I want to say, yeah, there are some features of the state-state dispute settlement. The first, I think, yeah, there exists a restricted scope of application. Yeah, than other investment treaties. Okay, for example, the first, yeah, under the Article 2, Article 6.2, the dispute referred to in Section 5 dispute settlement. Article 2 of the CAI does not include the dispute merely concerning the interpretation of the treaty. It shall be both. I mean, any disputes arising out of the interpretation and application, not only, yeah, maybe interpretation or the application, but both of them. I mean, yeah, concerning both interpretation and application of the treaty. Okay, so as arbitration panel is not authorized to award that the losing party is liable for compensation, and the implementation of the final reports by the losing party does not include monetary compensation. So the current SSDS mechanism only seems to apply to disputes relating to both the application and interpretation of the CAI, and the losing party is obliged to take measures, to remove the inconsistency of the measures complained of with the CAI, and excluding the compulsory monetary compensation. Okay, and it applies that the SS state disputes mechanism is focusing on maintaining the balance of rights and obligation of parties instead of the exact individual investors, rather than focus on the protection of interests of individual investors. Maybe, yeah, to protect the interests and rights of individual investors will be set aside to wait for the negotiation of the investor state dispute mechanism, yeah, within 2 years. Okay, and this later. Okay, so the second, about restricted scope of the application is that Section 4, investment and sustainable development, specifically provides for dispute settlement mechanism. Yeah, the title is quite different, which is called Mechanism to Address Differences. Okay, from the title, yeah, we can see there exists much difference between the state-state dispute settlements and the dispute settlement under the sustainable development clauses. So it means, yeah, apart from the title, the different title, there exists many other, much other difference between the two kinds of dispute settlement in one investment treaty. And not only the sustainable development clauses provides for the specific dispute settlement mechanism, and in the subsidy transparency, we also see that the CAI also provides for another quite different dispute settlement mechanism. So the dispute settlement rules on subsidies are also especially stipulated, and the consultation here is used as a major way to solve subsidy disputes. Okay, so I mean, it's very interesting that the application of SSDS mechanism seems to be restricted. Not only the disputes arising both interpretation and application of the covered provision, and here covered provisions also be excluded from the subsidy transparency clauses, and does not contain the subsidy and sustainable development clauses. So I think the application of S-state mechanism, its application scope has been sharply restricted. Okay, and the second feature.
Yeah, Professor, I'm very sorry to interrupt you. If you could conclude in a couple.
Okay, time is up.
Yeah, time is up, but
okay, yeah.
just please
I'm
conclude.
Sure
yeah, I'm very
feel,
sorry for the difficulties.
I'll finish within 2 minutes. Okay, so as for the features of this AI, and we can say it has restricted scope of application, and it has, of course, it has great inheritance and transformation of WTO dispute settlement mechanism, and of course, it has features of comprehensiveness and flexibility. And here I want to focus on the possible issues of the SSDI. The first, the possibility of politicization of dispute resolution. As we know, nowadays the EU Parliament has suspended its ratification procedure. Maybe even this procedure restart again. Especially about the neighbor issues will still become the focus during the whole ratification process. And this maybe in the future, even this CAI has been ratified during the implementation of the CAI, there's still strong possibility for the dispute resolution become politicized, okay? Because two parties have interest venues, okay? It's about venue issues, controversy. And the second, the last one, is the relationship between SSDS and mechanism ISM, okay? Because the parties have agreed to constitute negotiation on the mechanism and aim to complete within 2 years. Although the disputes under this mechanism are different from those under SSDS mechanism in terms of subject matter and claims, but I still suggest that two dispute settlements, although possibly to exist some controversy, but these should be allowed to be activated in relation to the same measure in the host country, as the course of action and the remedy on the two mechanisms are quite different and cannot be substituted for each other. Okay, of course, as far as conformity of the same measures of the host country with agreement as far as SSD mechanism, we should apply the connatural Istanbul to prohibit ISDS the tribunal from here the same dispute. Okay, so the main purpose of this principle is to give an overriding effect to the findings of fact or law in previous decisions, so as to avoid the same points of contention of the point of fact or law in previous decision, thus avoiding the duplication of litigation on the same point of dispute. Okay, that's what I want to say about maybe the possible issues arising out of the CAI in the future.
Okay, thank you very much, Professor.
I'm sorry because I cannot page down. I don't know why. So I'm sorry for that. It could not be.
Okay.
So,
okay. So I think we have some questions in the chat. So I will ask those who had posted them to formulate them. Just turn on your microphone and your webcam and make your questions. So I would like Professor Anderson, perhaps first. You had written a question in the chat, so if you want to make it, please go ahead.
Wait a second.
Thank you very much. And it's a question for Professor ZENG Wenge. And let me first of all thank you all for the very excellent and enlightening presentations you made here. But my question is for Professor ZENG Wenge. And it's about the Belt and Road Initiative. It's my understanding that it follows environmental policies. So my question is, how are these environmental policies, how are they implemented in practice? How are they materializing in these Belt and Road projects? Thank you.
And I think we could collect also the other question that Imad Ibrahim made. So please, if you want, go ahead and just make your question. Please turn on. Okay.
Yeah, hi. Thanks a lot for all the interesting presentations. So my first couple of questions are also for Professor Zheng. So the first question is, how would you describe current environmental regulations in China? And are they on par with the EU environmental regulations? I'm talking because I understand that there was an involvement of Chinese environmental regulations from the 80s until now, and now they're more or less more sophisticated, taking into consideration international regulations, especially for instance in the water sector. And how would that affect our info, like being in consideration with EU environmental regulations that are very sophisticated in this regard? That's the first question. My second question, Professor Zhang, also, well, given that the Chinese environmental regulations are becoming very sophisticated, are they being implemented elsewhere in the context of BRI or no? And what's the impact of EU environmental regulations on the Chinese environmental regulations in this regard, since there is concept exchange between both? So these are my couple of questions for Professor Zhang. I have a couple of questions as well to Professor Xueyan. First question is, how are the current provisions concerning SOEs within China's BRI agreements being perceived? Why I'm asking this, because before in the past, there were some criticisms towards Chinese SOEs abroad with the work they're being conducted in various countries. And so are there changes, and how did are there amendments to the regulations in a way that making sure that these SOEs, for instance, consider corporate social responsibility and are more, especially that the current Chinese approach is more acting towards more responsible regional or even local power. So I was wondering about whether that affected some changes to Chinese SOEs. And the second part is, well, the new regulations within BRIs concerning SOEs, are they drafted similarly to domestic law, or they usually take into consideration global influence and the country where they are being operating? So these are my couple of questions, and so I'll stop here for now.
Okay, I see that there is a raised hand from Professor Fahey. So if you want to make your question, please go ahead.
Hi, thank you so much for these fantastic presentations. I was just curious as to the place of RCEP. I mean, there's a lot of discussion in, about PPP, and just what is Chinese leadership regionally now? How do you understand this? How should we understand this idea of the areas? Because obviously, in areas where China is understood to be quite obstructive in international economic law, international environmental law terms, and so on. Just what kind of innovations do we expect, or what is the kind of the climate for Chinese leadership? I'm just very curious to hear that, because it's obviously extremely just in very recently that we're seeing really significant pushes. So just what the views on all this are. Thank you very much. That was fantastic. And I'm sorry to have my camera off because of the 4G. It's terrible. Thank you so much.
Okay, so thank you all for your questions, and I would go straight to the answers. So perhaps we can go reversely. So perhaps Professor Wu, you could start with your answer, and then we go on. Okay, Professor Wu, Xueyan, if you want to reply. Okay, perhaps she has some problems, so I don't know. Professor ZENG Wenge, do you want to reply to the question that were on the floor?
Yes,
Okay.
yes. Thanks, thanks. So many good questions. First, you talk about the Chinese regulation in environment law. For China, we have a very long time for have the legislation about the environment law. From the opening policy, we do a lot of the environmental regulations. Until now, we have the so many environmental law. For example, the pollution, anti-pollution, water protection, and some of the dispute resolutions, so many things. But meanwhile, we have some the shortage about the environmental law because China is a developing country. We did made a progress in the environmental regulation. Meanwhile, we also need develop the economic, so they keep the balance from the two. Meanwhile, we learn a lot from the European Union. We know the European Union, they focus on the environment law many years. They has so many advantage in the, for example, the climate change. So we learn from that. Meanwhile, we have some communicate with the European Union, have some cooperation in the climate change. For example, in the Paris meeting, Glasgow meeting, we have so many cooperation with the EU about the to the change of the climate change. This is the first question. Meanwhile, another professor has the question, the CPP, TPP's leadership. We know that for the first stage, the CPP leadership, from the USA, they're very strong. They have the very higher standard about the environment law. So they give the high standard environment law. So after that, after the American, we saw the pact, the Japanese and the Korea, the developed country also want to some high standard international standard. So they are the dominant about that. For China, we just want to accusation this CPTPP. We don't want to pursue the leadership because we are always developing country. So we just improve our environment law step by step. It's need a very long time. Meanwhile, we have some the decision from the central government want to for example, the no carbon economic. We want to climate change. We want to do that, but we have no powerful about that. Our money is very limited. Meanwhile, the economic is a developing country. So what we want to pursue the leadership, we just want to access it as a partnership for that. This is my answer. Thank you.
Thank you very much. And Professor Wu, if you want to reply to the questions. I'm sorry, we are running slightly late, so if we can keep them. Professor Wu? Professor? Can you hear us? Are you?
Can you hear me?
Yeah, we can. So please go ahead.
Okay. So as I said just now, China's position in the international rule regulation of SOEs is quite cautious. In contrast with the position approach of the US and the EU, China has constantly resisted the disciplines on SOEs in its FTA. So not other existing Chinese FTAs have included specific rules on SOEs, and it's the first time since because the rules, SOE rules under CI is relevant for the implementation of the One Belt One Road because the SOEs, Chinese SOEs, are main actors in the overseas investment. Those very big enterprises involved in the sectors and like energy, manufacturing, and construction. And so in the past, China's attitude is quite cautious, but now it's starting to change. As you might have already noticed that last year, China submitted a formal application to join the comprehensive and progressive Trans-Pacific Partnership. You know that the predecessor of that agreement is the TPP. Its rule, it's kind of designed with China as a major target. It sets out high standards has strict rules for SOEs, and China is going to take part in that agreement. Would like to express the willingness to take part in that agreement. So that's the attitude. That's why I said SOEs can be toward implementation, and China's attitude toward implementation of One Belt, One Road with the rules set out for the SOEs. And it's also the SOEs rules, is embodied in the newly elected foreign investment law, passed elected last year, in the year of 2019. And I know that's a cornerstone of the liberalization measures in of foreign in recent approved foreign investment law. And I know it's the Chinese SOEs is a big concern for foreign countries, but it's not difficult to find that the Chinese reform of SOEs has adopted an incremental approach. China's because while SOEs reforms were designed to tackle the obvious inefficiency and inherent in SOEs, they needed to be done slowly in order to preserve China's political and social stability. But now, the reform is continued. So the rules is also now not in very detailed regulation or laws, but it's embodied. It's newly elected foreign investment law. I don't know, did I answer your question?
Yes.
Yeah, I think so. Yeah, absolutely. So, Professor Yuan, if you have some final remarks, we are running late, but if you have some final brief remarks, please go ahead. Otherwise, we jump to the next panel.
I think I have briefly my remarks on the issues which may be in the future arising out of the multiplication of AI and the implementation of AI, especially the SFDS. And I want to stress that it's very important for both parties to address these issues. That is how to deal with the relationship and possible contradiction between the SSDS mechanism and the ISDS mechanism in the future, because as we know that the protection of the investors' rights and interests is also important for both parties. So in the future, there possibly should be a contradiction between the SSDS and ISDS mechanism, and it needs a great wisdom to deal with the relationship between the two kinds of mechanism. So as for my point, I think I do want to say it's the two mechanisms can achieve coexistence in the same AI agreement, because the complaining party, the interesting result, and the remedy is quite different between the two kinds of mechanism. However, of course, we have to do something to avoid the possible emerging parallel litigation. That means, after the SSDS dispute settlement, maybe complaining a company or an individual investor will also raise the ISDS suit under the same measures which has been ruled inconsistent with this AI agreement. How can we deal with that? Okay, I think we need some implementing mechanism to avoid this from happening. Okay, and I think one of important features about the SSDS mechanism under the AI, apart from the restricted application scope, and it also illustrates strong flexibility. I mean, it seems that some different kinds of covered provisions. If one party adopts a measures which could be alleged to be inconsistent with this agreement, maybe settled according to a different mechanism for dispute settlement. For example, apart from we have a special DSM for the subsidy, and we have different mechanism for dispute settlement for the sustainable development, and all other provisions disputes maybe will be submitted to the SSDS mechanism. Suppose maybe let us suppose that if one day a measures taken by one party which could be inconsistent with the sustainable development clauses and transparency and subsidies and other provisions of the CI, what kind of so here under this situation, what kind of mechanism, what kind of dispute settlement rules shall be applied in one disputes which contain all the provisions of the CI? So we have to deal with these issues, which I think maybe in the future possible right out of CI implementation and ratification. Okay.
Okay, thank you very much. And indeed, I would like to thank all the speakers we had today. And I apologize for the delay we're carrying, but we had some technical difficulties. I think I hope we can be excused on the ground of those. And so I would like to conclude this panel and give the floor to the next panel.
Thanks, Umberto.
Thanks again.
Thanks, Umberto. Thanks to all the speakers. I'll interrupt